Hi everyone, I'm Dr. Domenico Carolei and I'm a lecturer in public law and public international law at the University of Stirling. In this video I'm going to provide an overview of my conference paper called An International Ombudsman for Non-Governmental Organization. You are just too good to be true. The purpose of my paper is to examine the feasibility of an international ombudsman for the NGO sector, contributing to the policy and the academic debate on the regulation and the accountability of NGOs. Originating in the Swedish constitutional system, ombudsmen are independent officials empowered to resolve individual complaints about maladministration against government departments and public officials. Ombudsmen complement the role of courts, and they deal with complaints in a more informal and accessible way. Depending on the scheme, ombudsmen might be able to issue recommendations which, unlike a court order, are not strictly enforceable. Ombudsman scheme exists both at the national and at the international level. More recent developments in the field include the creation of ombudsman schemes that deal with complaints against private entities such as corporations. So far, there's no ombudsman that deals with complaints against a non-governmental organization at the international level. The idea of creating an ombudsman for the NGO sector emerged in 2018 in the aftermath of the Oxfam scandal, when the Times revealed that a staff member working for Oxfam in Haiti had allegedly paid earthquake survivors for sex. In addition to Oxfam, a number of inquiries have been launched by the charity commissions for England and Wales against well-established NGOs such as Save the Children and the WWF, revealing serious issues and lapses in their accountability systems. To respond to the calls for greater accountability in the NGO sector, the Dutch Ministry of Foreign Affairs commissioned a scoping study to the University of Rotterdam to test the feasibility of the establishment of an international ombudsman for the humanitarian and the development sector. In October 2019, the Dutch proposal was backed by the International Development Committee of the UK House of Commons, which urged the UK government, together with the Dutch government counterparts, to display international leadership in making the Ombudsman a reality. In the past few years, there has been an overlapping and growing consensus among scholars and policymakers that the NGO sector should move beyond self-regulation. In light of the accountability and safeguarding failures, particularly sexual abuse, that involved Oxfam and Save the Children. Regulating NGO is really tough. At the domestic level, more state regulation is rarely a viable route to promote more accountability in the NGO sector because of the risk of restrictive actions by governments that wish to silence NGOs for purely political reasons. At the international level, the global system is state-centric. NGOs do not possess legal personality under international law, and consequently they cannot be subjected to the same accountability standards and mechanisms meant for states, such as the international human rights law regime. This is why NGOs are under-regulated under international law, and as well as the reason why self-regulation has been the most popular way to promote and hold NGO accountable for the past 20 years. But as I mentioned earlier on, NGO self-regulation is losing credibility, and we need to search for new routes to enact NGO accountability, and one of them is the establishment of an international ombudsman. Considered as an unfeasible proposal avenue to enact NGO accountability in the 90s, the idea of the ombudsman is back in the spotlight with a brand new proposal put forward by the Dutch government. The Dutch proposal frames the ombuds as a joint sectoral entity that complements existing accountability mechanisms. It will be an external and independent body established at the international level, which is governed by different parts and components of the sector, and it will have international presence with technical experts on the grounds working in close cooperation with the NGOs. The complaint mechanism would be hierarchically organized into a two-tier system. The ombuds would play a complementary role in handling complaints against NGO, and the primary responsibility to deal with complaints rests on the organization. Consequently, the ombudsman would operate as an appeal body and could be reached after internal or sectoral organizational mechanisms have been exhausted. Now, the ombudsman would certainly fill an important regulatory and accountability gap in global governance, but there are some grey areas related to the creation of this body, some of which have been identified by the proposal itself. Logistic challenges, for example. Who is going to pay to support the creation of this body? Donors, the UN, NGOs themselves. And also legal challenges. What is the jurisdiction of the ombudsman, and how do we create this new body? Through an international treaty or a UN agency? What I argue in my paper is that the Dutch proposal is unlikely to succeed because three major challenges that have been not considered appropriately by the proposal itself. First, the Dutch proposal misinterprets the authority of the ombudsman because it frames this body as a replacement for criminal courts to deal with sexual abuse perpetrated in the NGO sector. This is not what the ombudsman is there for. Ombudsman schemes complement and do not replace the role of criminal courts. Second, the proposal does not learn any lessons from existing ombudsman schemes available in the private and in the public sector, neglecting that ombudsmen present limitations in promoting accountability. And third, the proposal lacks support from NGO themselves, which are driving force behind the establishment of accountability mechanisms at the international level, and should be seen as the principal standard sector for an instrument like the proposed ombudsman. What I do in my paper is to provide a series of recommendations to mitigate these key challenges, and simultaneously I identified alternative routes to enact NGO accountability at the international level, such as extraterritorial jurisdiction. This consists in holding an NGO accountable for misconduct perpetrated overseas, so in host countries, using the law of the country where the NGO is registered or headquartered, so the home country, to operate internationally. Another route consists of applying the international business and human rights framework meant for corporations to NGOs. There is a growing number of NGOs that have signed the UN Global Compact, coupled with an emerging case law that indicates that the OECD guidelines for multinational enterprise apply to NGOs, although NGOs are formally. Over the past few years, there have been a number of complaints filed against NGOs under the OECD guideline for multinational enterprise. including one complaint filed against the WWF for facilitating human rights abuses of indigenous group in southeast Cameroon. Should you wish to learn more about my research findings, read the conference paper for now. I also have an open access article recently published by the Non-Profit Policy Forum entitled Accountability Beyond Corporations, applying the OECD guidelines for multinational corporations to non-profit organizations. Later this year, you will be able to read my article, Accountability for Human Rights, applying the business human rights framework to NGO on the next issue of the Journal of Human Rights Practice, published by Oxford University Press. And finally, my book on the regulation and the accountability of NGO will be published by Routledge next year. So watch this space.